everyone, good afternoon and welcome back to Thorough Newspaper Analysis. This is TNA of 8th of September and this entire video series, it's brought to you by LawSikho. So now let's head to the agenda for today. For the editorial segment, we have a very interesting article which was published in the Indian Express and its title is Mercy Petitions, How Changes Which Are Proposed in the Bharatiya Nagrik Suraksha Sanhita. This is the proposed replacement of CRPC. So how the changes which are proposed in this Sanhita with respect to mercy petitions, they ignore the legal precedents. Second segment for today's discussion would be the news update segment. And thirdly, we have a look at the legal news of the day. So let's start with this article without further ado, and let's start with the context of it first. The Bharatiya Nagrik Suraksha Sanhita 2023, which is the proposed replacement of the Criminal Procedure Code, it contains a new provision on mercy petitions in death sentence cases. This latter half of this para, it deals with a comparison of some sort of these changes. This is quite technical. So I believe first we should look at what is mercy petition, then what are the proposed changes, then what are the precedents, and then we come back to the latter half of this para. So let's start with Article 72 for understanding what is mercy petition. This article, it states, the President shall have the power to grant pardons, reprieves, respites, or remissions of punishment, or to suspend, remit, or commute the sentence of any person who is convicted of any offense where the sentence is a sentence of death. Similarly, we have Article 161. It confers the pardoning powers of the governor, but these do not extend to death sentences. There are a couple of terms which are important, and as judiciary aspirants, we often confuse these terms. I would very briefly like to highlight. So, pardon, as the term itself suggests, it would mean that your convict, he is absolutely exonerated and he is absolved of any sort of penal liability. So, he's absolutely set free. That is pardon. Then comes the term reprieve. So, reprieve, it essentially involves a stay, a temporary stay on the execution of a sentence, especially a death sentence. And why this temporary stay is imposed? So that the convict has time to seek pardon or commutation from the president. Now, the third term before us is respite. Respite, it denotes the awarding of lesser sentence. So let's say XYZ sentence was originally awarded. Now the sentence is termed into a lesser severe sentence. And what is the reason for that? This is because of some special fact, such as the physical disability of the convict, or let's say there is a woman offender and she is pregnant. So considering these special circumstances, lesser sentence is given. Third term is remissions. So remission, it implies the reduction of the period of sentence, but here the character of the sentence is not changed. So let's say I was given a 9-year term sentence. So this imprisonment is turned to a 4-year tenure. So that is remission. Then we have the sentence, or then we have the term which is called commutation. In commutation, the character, see, you can like put this trick in the mind and remember, C for commutation, C for character. So here character of the sentence is also changed. For instance, your death sentence, it is changed to let's say LI. So that is that's about it. Now, there is a case law which is called the case of Maru Ram versus Union of India. This is a 1981 judgment. Here, the Supreme Court held that while deciding mercy petition under Article 72, the President must act on the advice of the Council of Ministers. Under the existing law, the President is bound by the Cabinet's advice and he can only return the plea for reconsideration once under Article 74. And if after reconsideration, the Cabinet or the Council of Ministers, it shares the same again, then there is no scope for the President to refuse. She has no option but to accept these. Now, let's understand as to what are the new provisions or changes under the Sanhita. The provision in the proposed Sanhita, it however does not include any such requirement for the President to act in tandem with the advice which is given by the Council of Ministers in death sentence cases. Section 473, subsection 1 of the Sanhita, it allows a convict under the sentence of death or his legal heir or any relative to file a mercy petition before the president under Article 72 or before the governor for the state under Article 161 of the Indian Constitution. And the time period for the same is 30 days after the date on which the jail superintendent has done these two, which is after the jail superintendent informs him about the dismissal of the appeal or the special leave to appeal by the Supreme Court, or informs him about the date of confirmation of the sentence of death by the High Court, and the time which is allowed to file an appeal or special leave in the Supreme Court, it has already expired. So following this, the mercy petition, it may be presented to the center or the state government's home department, as the case may be. While the mercy petitions under subsection 1, it may initially be made to the governor, his rejection or disposal of the petition, it is going to result in it being forwarded to the president, and this has to be done within a period of 60 days from such either rejection or disposal of the plea. In cases where there are multiple convicts, the jail superintendent or the officer in charge shall ensure that every convict makes a mercy petition within a period of 60 days. And if the superintendent does not receive the mercy petition from, let's say, all the convicts in the case, then he is duty bound. He shall himself send the names, the addresses, the copy of the record of the case, and all the other details of the case to the central government or the state government for consideration along with the said mercy petition. On receiving the mercy petition, the center will seek the state government's comments, consider the petition along with the case records, and then make recommendations to the president in this behalf as expeditiously as possible, which means as fast as possible, within 60 days from the date on which it received the comments of the state government and records from the jail superintendent, because then it has to make its decision. So these material, it is necessary. Now, while this 60 days time limit, it has been given to the center, no such time limit has been prescribed for the president to dispose of the mercy petitions. After this, the president may decide and dispose of the plea. However, in case of multiple convicts in a case, the president shall, these petitions, they shall be decided by the president together in the interest of justice. Now, once the president's decision on the status of the plea, it is received by the center, then it shall, within a period of 48 hours, communicate the same to the state government's home department and the superintendent of the jail or its officer in charge. Notably, subsection 7 of section 473 states that no appeal shall lie in any court against the order of the president made under Article 72 of the Constitution. So this means that this order of the president shall now become final. And under this proposed Sanhita, it has given finality, it has been given finality, and the scope of judicial review, it is done away with. And it further says that it shall be final, that is, this decision of the president shall be final, and any question as to the arriving of the decision of the president, it shall not be inquired in any court. So in a nutshell, this provision, it aims to do away with the appeals against the president's decision on mercy petitions, thereby making it final. It also means that the court will no longer be able to go into the grounds on which the president pardons or commutes death sentences. Let's see what has been the long-standing precedents on this, on the matter of death, the mercy petition. So for that, we go back to October 2006 in the case of Ipiru, Sudhakar and another versus Andhra Pradesh and others. Here, the Supreme Court held that the power of the president or the governor under Articles 72 and 161 respectively, they are subject to judicial review. Such a decision, it can be challenged on the grounds. These are the grounds. So when can such decision be challenged? If it is passed without any application of mind, if it is malified, which is with bad intent, and it is passed on considerations which are completely or wholly irrelevant, and relevant materials which are kept, which should have been considered, they have been kept out of consideration, and it suffers from arbitrariness. However, the proposed Sanhita, as we've already discussed, by virtue of subsection 7 here, it specifically says that the President's decision, it shall be final and it shall not be subject of any inquiry in any court. Then we come to 2014, where in the case of Shatrughan Chauhan Nadar versus Union of India, a three-judge bench of the Supreme Court, it commuted death sentence of 15 convicts and observed that Article 21, it inheres a right in every prisoner till his last breath, and this court will protect the right even if the noose is being tied on the condemned prisoner's neck. Additionally, the court laid down guidelines safeguarding the interest of death row convicts. And one such guideline, it was providing a minimum period between the rejection of the mercy petition being communicated to the prisoner and his family and the scheduled death of execution. So there has to be some gap between these two events. Noting the differing periods across prison manuals in this regard, the court it thought it necessary that a minimum period of 14 days it should be stipulated between the receipt of communication of the rejection of mercy petition and the scheduled date of execution. So there has to be a gap of 14 days to allow the prisoner to prepare himself mentally for execution and deal with his earthly affairs, such as meeting with his family, among other considerations. However, if we have a look at the provision proposed in the Sanhita, no such 2 weeks period has been mentioned. Finally, in the case of Shatrughan, the bench, which is led by former Chief Justice P. Sath Shivam, it ruled that there was no explanation for the inordinate delay in disposal of mercy petitions by the President. The bench stated, and I quote, accordingly, if there is undue, there is unexplained and inordinate delay in execution due to pendency of mercy petitions, or the executive as well as the constitutional authorities, they have failed to take note of or consider the relevant aspects, then this court, it is well within its powers under Article 32 to hear the grievance of the convict and to commute the death sentence into life imprisonment on this ground alone. However, only after satisfying that the delay was not caused at the instance of the accused himself. But if we have a look at the proposed Sanhita, there is no time limit for the President to decide the mercy plea. Now let's go to the latter half of this para. So what are the changes? The changes, they include core aspects of, it has changed the fundamental nature of the provision, including core aspects of its justiciability, the time limit within which such pleas must be decided, and the 14 days gap between the rejection of mercy plea by the President and its date of execution, as was mentioned in the case of Shatrughan Chauhan. And now let's proceed to the national news category for today. And here, this is the first update. India extends support to SCO member countries to enhance legal and judicial capabilities. India, it has extended support to the Shanghai Cooperation Organization members, popularly called the SCO, member countries to enhance the legal and judicial capabilities. The 10th meeting of the Ministers of Law and Justice of SCO countries, it was held through video conferencing on 5th of September. Speaking on the occasion, the Minister of State for Law and Justice, Arjun Ram Meghwal, representing India, he emphasized India's commitment to the SCO Charter and its principles of mutual trust, of respect for sovereignty and territorial integrity and mutual benefit. The minister said, this commitment, it is based on the Prime Minister's vision that India has emerged as a Vishwamitra. Mr. Meghwal, he highlighted how India, it has embarked on a path of legal reforms, and he added that 1,486 such laws which have become archaic and not relevant, they have been repealed, and more such archaic law, they are on the process of being identified. He also highlighted the changes which the bills that have been proposed to replace the laws which constitute essentially our criminal system, which is the IPC, CRPC, and evidence, that has also been made a reference of. Also, in the meeting, a joint statement was signed by all the members, the ministers of justice of the SCO member countries, that emphasize on cooperation in the field of law and justice. Let's talk about SCO in case, from the point of view of the exams. So it is a permanent intergovernmental international organization created in 2001. Charter was signed in 2002 and came into force next year in 2003. Its members, the full-time members, are India, Kazakhstan, China, Kyrgyzstan, Russia, Pakistan, Tajikistan, Uzbekistan. While 4 countries, they have an observer status. These countries are Afghanistan, Belarus, Iran, and Mongolia. Then 6 countries, they have dialogue partner status. These are Azerbaijan, Armenia, Cambodia, Nepal, Turkey, and Sri Lanka. The official language of the SCO Secretariat is Russian and Chinese. The Indian Renewable Energy Development Agency, it has signed an MOU with the Union Bank of India and the Bank of Baroda to co-finance renewable energy projects. Through the agreement, the IREDA, it will collaborate with the banks in co-lending and loan syndication of emerging and established renewable energy projects. Union Bank of India, it said that the MOU, it will come into effect immediately and it is valid for a period of 5 long years and it will be executed if both the parties consent. The bank further added that the collaboration will include co-originating projects, including small hydro projects and ethanol projects. Moving on to the next update. Malaviya Mission Teachers Training Program, it is launched by Shri Dharmendra Pradhan and UGC. The Union Minister for Education and Skill Development and Entrepreneurship, Shri Dharmendra Pradhan, he launched the Malaviya Mission Teachers Training Program by the UGC, the University Grants Commission. This was done in New Delhi. He inaugurated the portal of the program and released its information brochure. Let's understand some of the highlights of this program. It aims to provide tailored training program for teachers. It will work for the capacity building of faculty members of higher education institutions, and it will ensure continuous professional development and help in building capacities of 15 lakh teachers in the higher educational institutions through 111, that is 111 Malaviya mission centers across India in a time-bound manner. Further, the human resource development centers, they have been revamped and renamed as Madan Mohan Malviya Teachers Training Centers. Also, the teachers training, they will be trained in such a way that they build leadership skills and it is aligned with the new educational policy. Himachal CM launches scheme for specially abled children. He announces to set up the Rajya Chayan Aayog. The Himachal CM, he recently launched the Mukhyamantri Spotting Abilities, Rebuilding Aspirations and Livelihood scheme from his home assembly segment, Nadon, in his district. The Chief Minister, he also announced to set up a Rajya Chayan Aayog in place of the new dissolved Himachal Pradesh Staff Selection Commission in Hamirpur within the month or next 2 months. This is to ensure fairness in the selection criteria of candidates, because we've seen that at times the exams which are conducted by the state governments, they are fraught with a lot of corruption and there are other ill practices as well. There is a delay in conducting the examination process, so on and so forth. So this scheme, it intends to take care of specially abled children in around 400 schools across Hamirpur, Solan and Shimla district. Simultaneously, the CM also launched Abhyas Himachal and Shikshak Sahayata chat box. These are accessible via the Swift chat app. This offers easy, similar, access. It is similar to that of WhatsApp and it is powered by the conversational artificial intelligence. He also launched a Sampark Science TV program, which is designed to transform ordinary TVs into smart TVs. The Chief Minister announced to set up Rajya Chayan Aayog in place of the Staff Selection Commission in Hamirpur that we've already discussed. Ahmedabad, it becomes the second city in the country to implement emission trading scheme. The Gujarat government, it has announced that Ahmedabad has become the second city in our country to implement an emission trading scheme for particulate pollution that will help in regulating industrial emissions, and it is going to reduce the state's pollution levels. The scheme, it empowers industries in the textile sector within the Narol and Vatva industrial clusters. The scheme, it is implemented by the Gujarat Pollution Control Board, and this is with technical experts by professors from universities like that of Chicago and Yale. The scheme, it caps the amount of pollution which is allowed from regulated industries, and it also allots permits to plants. Amul is the official sponsor of Indian contingent at the Hangzhou Asian Games. Amul, it is named as the official sponsor of the Indian contingent for the 19th Asian Games of 2022, which were initially scheduled in the year 2022, but owing to the COVID pandemic, it is now being shifted to this year. So it is to be held in Hangzhou in China from 23rd of September to 8th of October. As per this association, Amul will use the integrated logo in its communication to celebrate the efforts of the sports persons. If we have a look at this tournament, it is the 19th edition. It will feature around 482 events across 40 sporting categories. This has brought us to the international segment for today, and this is our very first update here. Japan, it launches Moon Sniper lunar mission. On Thursday, Japan, it has launched a lunar mission after overcoming multiple delays owing to unfavorable weather conditions. The H-2A rocket, it blasted off from the Tanegashima Space Center in southern Japan, as per the statement released by the country's space agency. The rocket, it is carrying the country's Moon Sniper lander, which is expected to touch down on the surface of the moon in 4 to 6 months. This lander, which is officially called the Smart Lander for Investigating Moon, it is designated to land within 100 meters of a specific target on the moon, and this is very less than the usual range of several kilometers. This is a successful attempt. However, we need to understand that there have been a lot of failed attempts as well. Several lunar landing attempts by Japan, they've failed, including last year when it sent a probe which is called the Omotenashi as part of the US Artemis program. It would have been the world's smallest moon lander, but it lost contact. The Thursday's launch, it comes 2 weeks after India's successful triumph by the successful landing of the Chandrayaan-3 on the moon's southern pole, and therefore India has become the first country to land a probe on the south pole of the lunar surface. AI CEO Sam Altman, he becomes the first person to get Indonesian golden visa. This move by the country, it is to secure foreign investments. The country's immigration authority has issued a 10-year visa for Altman, as he has an international reputation and he may bring benefits to Indonesia, the immigration director of the nation said. The co-founder of ChatGPT creator, he would enjoy priority security screening at the airports, longer stay periods, easier entry and exit processes, among the other perks and benefits. Introduced last week to boost economic development, this new visa, it allows foreigners to make substantial investments in the country to remain for between 5 to 10 years. Since their debut last year, OpenAI's tools, they have spurred a rush in investment into AI supporting infrastructures by showcasing the potential of human-like intelligence using vast data centers. And this is the last update in the international segment. Vanuatu, it elects Sato Kilman as the Prime Minister. Vanuatu, which is a South Pacific Ocean nation, its parliament has elected Sato Kilman as the nation's new Prime Minister. Now, this update, it is a very interesting update because there have been a lot of political events that unfolded. Essentially, the former prime minister, he was ruled out via a no confidence motion, and thereafter he approached the courts. The courts also upheld the same, and hence the present prime minister came to be elected. So, the parliament, it elected Sato Kilman as the nation's new prime minister after the court upheld a vote of no confidence in the nation's former leader, and this is amid the US China rivalry in the Pacific Islands. Kilman is a former prime minister and leader of the People's Progressive Party. He was elected as the prime minister in a secret ballot by the MPs, and this nation, it is plunged with political crisis last month when opposition parties lodged a no confidence petition criticizing then leader Ismail Kalsakau for its or his actions, including signing a security pact with Australia. So, as and when the security pact was signed, this spurred a lot of opposition. Uh, we need to here understand that this island nations, this Pacific Ocean nation, its location is very strategic. Why? Because it is at the center of a strategic rivalry between China and the Western countries in the region. So, therefore, United States and its allies, they're seeking to dissuade Pacific Island nations from establishing security ties with China after it signed a security pact with the Solomon Islands. Now, with this, we come to the legal update segment for today, and this is our very first update here. What is cruelty for a woman? It may not be cruelty for a man. More broad approach, it is needed when wife seeks divorce, the Supreme Court has stated. The name of this particular matter is XXS versus YYY. This is because of family law matter, so therefore the names have been concealed. So while allowing a petition filed by an estranged wife seeking divorce, the Supreme Court, it has stated that the word cruelty under Section 13, subsection 1, clause IA of the Hindu Marriage Act, it gives wide discretion to the court to apply it liberally and also contextually. So the bench further observed that an element of subjectivity, it has to be applied, albeit the what constitute cruelty, it is objective. Therefore, what is cruelty for a woman in a given case, it may not be cruelty for a man, and a relatively more elastic and broad approach, it is therefore required when we examine a case in which a wife seeks divorce. Next update also comes from the Honorable Apex Court. So here the Supreme Court has ruled that it is permissible for the legislature to remove a defect in an earlier legislation. The court said that the defect, it can be removed both prospectively, which means it is going to come in effect on a future date, and retrospectively, which means coming in effect from a back date by a legislative process, and previous actions can also be validated. However, where a legislature, it merely seeks to validate the acts carried out under a previous legislation which has been struck down or rendered inoperative by a court by a subsequent legislation without curing the defects in such legislation, then the subsequent legislation would be ultra vires, the division bench has held. Further, the bench remarked that such instances, they would amount to an attempt of judicial overrule a court's judgment by a legislative fiat, and it would therefore be illegal and an instance of colorable legislation. The name of this particular matter is NHPC Limited versus the State of Himachal Pradesh Secretary and others. And with this, we come to an end of today's TNA. In case you want to get access to the free study material that we curate or the CNA slides that have been used in this video, I would invite all of you to please join our Telegram channel. And for the same, you may click on the link which is given in the description, or you may scan the barcode here. These are the point of contacts in case you want to get in touch with LawSikho. Thank you for being with us.